Hey, once again, second time today. I've been live so much over the last week. Oh, and listen, my tolerance for BS is at an all-time low. My BS tolerance has flatlined. I'm telling you that right now. The last few days, I've been live streaming, reading College of Policing document about the Nicola Bully case. Well, that's generated a whole bunch of BS. Well, and then, well, I knew there was going to be. I can't even speak. I knew there was going to be BS as soon as the Supreme Court of Indiana court filings started to come in. So we've got 2 court filings to go through. One from Judge Francis C. Gull, and the other one from the Attorney General. Aussie TV member for 12 months. 12 months. Thank you, thank you. Okay, so we're going to do the Attorney General's first, because that came in first. That just kind of sets the scene for the level of BS that we're actually dealing with here. Yeah. How is everyone? I hope you're all right. I think some of you were in the live earlier. But, okay. All right. I'm going to start reading. So I put the first page of each of these filings on my community wall. And I just want to make it really clear before I start reading this document. This is from Theodore Rakita, the Indiana Attorney General. That the Attorney General has absolutely no sway in the decision that the Supreme Court of Indiana is going to do. All right. When they're going to do that, I have no idea. Don't ask me. I have no idea. Might be tomorrow, might be in 3 weeks, might be in a month. Who knows? I don't know. I don't know how long they take to decide these things. But the special judge person at the Supreme Court of Indiana, the one who signs all the letters, is Loretta Rush. The Attorney General, Theodore Rakita, is not making the decision. So if you're under the impression that Theodore's word is final and they've thrown out the writ, that is not true. That is not true. Theodore is, he seems to be sitting on the fence, or up to me reading this, it appeared to be him sitting on the fence, because according to Judge Francis C. Gull, one of the reasons why she needed extensions to get responses to both of the writs in was because the Attorney General had declined to represent her, and therefore she had to get her own private counsel. And then a few days ago, it seemed that Theodore wanted to put a response in. Now, I don't know why. What else? A concerned colleague, an interesting party? I don't know. All right. But the nonsense that he's written, how has this man become the Attorney General? Because the level of BS that he's spewing, I don't know, did no one else apply for the job? Are they very short of potential Attorney General candidates in Indiana, because if he thinks he's sounding smart, he's not. This is just an exercise in circular argumentation. That's all. Anyway, okay, I'm not going to read it word for word because this is 22 pages and the other one from Gull is about the same. But you know, you can skip the first few pages because it's contents and citations. Well, that's it. Yeah. I can't comment on Trump because he's never been my president, but Bojo, oh dear God, do not mention Bojo in this room. Okay, all right. So this came in first. That's why I'm reading it first. And also, I've read a little more of this. I've only read the first couple of pages of Francis Gull's, and was ready to throw in the towel. I just think I don't care. This is just BS. This is just 100% unbelievable. Unbelievable. All right. Indiana Attorney General Todd Rokita, pursuant to Rule 3F of the Indiana Rules for Procedure of Original Actions, files his response to Allen's verified petition for writ of mandamus and prohibition. Okay, so 2017, 2 teen girls, who everybody seems to have forgotten here in this case, were murdered near the Monon High Bridge Trail in Delphi, Indiana. Richard Allen was charged with the murder on October 28th, 2022. November 14th, Special Judge Francis Gull spelt her name wrong, spelt her name in the male way, but who knows, appointed Bradley Rosie and Andrew Baldwin to represent Allen. Okay. October 2023, discovery subject to a protective order was leaked to the public. Do I need to say again? Do I need to say one more time that leaks have been coming out from this case since the beginning? Since before Allen was arrested, since before Bradley and Rosie were ever involved, because Allen hadn't been arrested then. And we know from Detective Jerry Holman himself, he said leaks have been difficult to contain in this case. We've had Barbara MacDonald sitting there with the Purdue report on Court TV. We've had Chris Todd describing the crime scene photos on Court TV in December. So I don't know what to tell you. Member for 13 months, Pottermouse. Thank you. Okay. And it wasn't. Oh, no, I'll carry on. On October 12th, Attorney Rosie wrote to the court acknowledging that the defense team was the source of the leak and arguing that disqualification of attorneys Rosie and Baldwin were not the appropriate remedy. Gull set a hearing for October 19th to discuss the upcoming hearing on October 31st and other matters which have arisen. Okay. Baldwin retained an attorney for the hearing. Okay. All right. So there was discussion. Let's get this clear. There was apparently a phone call between them all. There was a series of emails, which we've read, but no formal filing of a disqualification motion. Okay, that's important. Because the hearing that Gull called on the 19th was supposedly to discuss things. All right. It was a discussion. And also to, talk about the October 31st hearing, which had already been in the schedule for a while. All right. So Slick Nick McClelland, whose suggestion it was to disqualify Rosie and Baldwin, turned up with a bunch of witnesses ready to present evidence and exhibits at this hearing. Rosie had emailed asking for clarification on what this hearing was about and was told to turn up at Chambers at 12 noon or 12:30, despite this hearing only beginning at 2 p.m. And it was then, and we've read the transcript, this in Chambers meeting, which was on the record, where Francis Gull basically stitched up Baldwin and Rosie. McClelland had come with his witnesses, so he knew the real purpose of the hearing. Baldwin and Rosie had no choice but to say that they would withdraw, because if they'd gone out into open court, they'd have been made to look like a laughingstock, because it would just look like they were unprepared, that they didn't have any witnesses, they didn't have any reply, because they'd not seen the exhibits that Slick Nick had put together. So they hadn't had the opportunity. There was no motion filed for a disqualification hearing. They did not have the opportunity to bring any witnesses of their own or to examine the exhibits that they were going to be, quote unquote, tried against. So just bear that in mind. All right. Chambers meeting before the hearing, Judge Gull informed Baldwin and Rosie of her concerns regarding the defence team and the totality of the circumstances surrounding your representation of Mr. Allen. So this is what Judge Gull highlighted. Bear in mind, there's no presentation of evidence at a formal hearing at all. No opportunity for Baldwin and Rosie to bring opposition to this. And we've read the transcript. We've read how it went down. Okay. Improper comments to the public. Oh, and I will say that I've discussed all of these at length in my videos. So we're going over the same ground again and again and again. It's like Groundhog Day. Improper comments to the public. After stating they would not talk about the case, Baldwin and Rosie issued a press release that was potentially violative of ethical rules. Which ethical rules? Which rules? Which rules? Because the gag order wasn't in place then. And I've got the press release, shown the press release in a video. Heard what Baldwin said to the press, none of which was improper, none of which was untrue. All right. Conflict of interest. I like the way that the Attorney General has slipped in that term, conflict of interest, because this is against Rosie, who previously Gull had no argument with, except for telling him no, he can't continue to represent Allen. But the Attorney General has slipped in conflict of interest, because that is one issue that if there is a conflict of interest, an attorney can be disqualified. Right. So now he's saying that there's a conflict of interest because Rosie filed a tort claim on Allen's behalf against Westville. Well, he filed a notice of tort. Okay. And if that was so much of a conflict of interest at the time, because this was months ago, okay, so this, the first one, was November, 1st of December, I think the press release came out, okay, and then this was months ago, can't remember exactly what date, but it was months ago that happened. So neither of these Gull has questioned previously, okay. And if she had such a problem with it, why didn't she say, Rosie, filing a tort, you know, is putting yourself in a awkward position there, you know, and Rosie might think, well, somebody else can file that tort claim. Okay. All right. And it wasn't a case that was ongoing. It was a notice that a tort would be claimed in the future. Okay. Protective order violation. Baldwin negligently released discovery to Brandon Woodhouse. No, he didn't. No, he didn't. Didn't release any discovery. He released and it was a complete mistake. Yes, it was an error. It was a bunch of like bullet points. It was like an index, if you will, of what was on a USB drive. You can't make anything out. There's nothing that would in any way prejudice the case at all. Okay, so there's that. Filing motions with inaccuracies and falsehoods. Pleadings regarding safekeeping of Richard Allen at Westville contains proven false information. So the proven falsities come from the warden of the prison and come from the prosecution. Okay. Both of whom want to keep him there for their own reasons. And then we get the final one, the protective order violation. Baldwin was the source of more leaked discovery, which spawned a criminal investigation and may have resulted in a suicide. Now, that is a spectacular claim to make. That Theodore Rakita seems to know why Robert Fortson took his own life. Okay. Judge Gull stated that she did not want to say this in open court, but would if she had to. Yeah. So she didn't want to have a hearing. So is that why she didn't file a motion to disqualify them? Because she didn't actually want to have a hearing? Why didn't she want to have a hearing? Because she realised that she was on very shaky ground, maybe. Just a suggestion. Gull confirmed that if Baldwin and Rosie did not withdraw, she would remove them. Okay, so she can just remove them willy-nilly. All right, okay. So they withdrew, so we know that. Right, okay. And bear in mind, none of this is in the presence of Richard Allen. In open court without Baldwin and Rosie present, Judge Gull announced they are withdrawn. Okay. So then we know about Rosie tendering two documents on the 25th and the 26th. Okay. We know about those. We know about Baldwin's attorney, David Hennessy, filing a motion. Okay. And then at the hearing on October 31st, Baldwin and Rosie were present. Okay. Because they said they continued to, they weren't going to withdraw. They were continuing to represent Richard Allen because that's what he wanted, and he'd put that in writing. Okay. So we get this. Okay. No attempt was made to appeal Judge Gull's order. What? No attempt was made to appeal Judge Gull's order. What order? What order? Okay. On November 6th, 2023, attorneys Cara and Mark Lehman filed a petition of writ of mandamus. So he's going to say that it's not appropriate to have a writ of mandamus. And here's his argument. Now, I'm not going to read all the references, but you can just go and look up those citations if you want to. So an original action is limited remedy governed by strict procedural rules. All right. So apparently you're meant to appeal to the trial court first before appealing to the Supreme Court. Okay. All right. And then we get this. The request that the court reinstate Baldwin and Rosie as Alan's court-appointed attorneys is inappropriate for a writ. Okay. So the conditions precedent for a writ not satisfied as the claim was not clearly presented to the trial court and a remedy by appeal is adequate. So because they supposedly didn't appeal, but what were they appealing to? What were they appealing to? Because there'd been no hearing. Okay. Because unless you have a motion to disqualify, then you don't have a hearing. And if you don't have a hearing, you can't issue an order to disqualify. So when I said this was circular, and it's just like Groundhog Day, it's like Groundhog Day, and we're going round in circles. So, okay, so Alan didn't seek, I can't say it, interlocutory. So it's an appeal whilst, so it's not having to wait till the end of a trial. Okay, so it's an appeal whilst the case is ongoing. Okay. So the record does not indicate that Alan asked his newly appointed counsel to appeal. So his newly appointed counsel that are friends of Judge Gull and who Richard Allen does not want to represent him. So do you think that Richard Allen is getting adequate counsel? Do you think Richard Allen has suddenly swallowed a law book? You know, he's eaten that much paperwork that he's absorbed a whole bunch of law that he understands without being counselled that he can launch an appeal via his new attorneys. So Richard Allen has got to have the foresight to be able to ask his newly appointed counsel, who he doesn't know, who are friends of the judge, who certainly Libretto sounds like a complete bastard in my opinion, to appeal against the disqualification of his previous attorneys. How's that working? How's that going to work in anybody's logic? How does that work in anybody's logic? Okay, no. Doesn't work. Okay. So it goes into disqualification of counsel. All right. So then says it can be at the discretion of the trial court. So apparently a court can just come along and disqualify attorneys willy-nilly now with no hearings or nothing, no formal process, no. Apparently. Okay. So got some citations here. Okay. So he's even admitting here that this citation, though this court reviewed disqualification of counsel through original actions. So, okay. So a court like the Supreme Court can review a disqualification of counsel through an original action like the one that's been filed. Okay. Glad we've got that clear. The court has not issued a writ to reverse a trial court's discretionary removal of counsel. Yes, it's very unusual, but these are extraordinary times. Okay, so we've got more bollocks here. All right. So Richard Allen does not identify an absolute duty to reject counsel's withdrawal. Okay. Or to permit them to reinstate representation. So the law does not place an absolute duty upon courts not to interfere with the attorney-client relationship. But it's okay for a judge to ask the opinion of the prosecutor as to whether or not to disqualify his opposition, who is scared of taking him to trial in a couple of months that he's not prepared for. But it bars arbitrary and unjustified interference. Great. Good stuff. All right. Can all go back to bed then, can't we? Allen contends that respondent acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. Well, no, I don't think she did have an absolute duty to refrain from doing so. What she had a duty to do was follow due process. If she'd a motion to disqualify, had a hearing with adequate notice, so both sides could have brought witnesses, exhibits, had the opportunity to cross-examine those witnesses and those exhibits, and then made a fair and judge ruling that she then ordered, okay, that's due process. Whatever happened as a result of that, I'd have been okay with. What I don't have an issue with is the law being followed, however that turns out. But what we don't have at the moment is clarity on what goes on in Judge Gull's head, or these private conversations between Gull and McClelland, which clearly went on because McClelland brought his witnesses and his exhibits to court on the 19th. So apparently Allen does not identify the origin of this absolute duty. All right, whatever. The right to choose counsel or continue representation is not absolute. Okay. All right. Indigent defendants do not have the right to choose appointed counsel. No, but the counsel that he wanted and who wanted to represent him were prepared to work pro bono. Okay. So the right to choose counsel is not absolute. While the right to select and be represented by one's preferred attorney is comprehended by the Sixth Amendment, the essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than ensure that a defendant will inexorably be represented by the lawyer whom he prefers. Okay. All right. Well, I'll go back to saying Richard Allen should represent himself, because he has a right to represent himself. And then he could employ Baldwin and Rosie as his advisors. I don't think they could argue with that, because he has a right to represent himself. Some more law there. The right to counsel must be balanced with the need for a fair trial. Think Allen's getting a fair trial now? No. Okay. So instead of going to trial in January, he's got to wait until at least October the 15th of next year. So a whole year, when the trial was good to go from Richard Allen's side. So what's not fair about that? Is it Slick Nick who doesn't think it's fair? Because if Slick Nick had all of this evidence that people keep telling me that he's got, he should be chomping at the bit to go and show these upstarts, Baldwin and Rosie, all this nonsense about Odinism. Should be prepared to go and just throw it all down the drain, bowl them over with all of this evidence. That would be a fair trial, but no. Okay. So, counsel's conduct or personal circumstances may justify removal. Gross incompetence or physical incapacity to counsel. So gross incompetence, well, we've no evidence that that's occurred. No evidence at all that that's occurred. I think his defence has been very rigorous and very clever. Yes, there's been mistakes along the way, like sending the email to a wrong person. Okay, that's a mistake. Hold your hand up, admit it. But to say that's grossly negligent or grossly incompetent, I think that's a stretch too far, just in my opinion. Okay, so all the reasons why they can disqualify attorneys, loads of law there. The lack of record prevents review of counsel's disqualification. Wait. The lack of record prevents review of counsel's disqualification. But I thought Frances Gull had recorded it. I thought she'd recorded that they'd withdrawn. Defence counsel's withdrawal truncated the proceedings, and the present record prohibits complete review of whether the trial court's concerns justified substitution of counsel. So we've no record of their disqualification being justified. Let that sink in. This is coming from the Attorney General, who's supposedly on the side of Frances Gull. Let that sentence sink in. I'll say it again. Defence counsel's withdrawal truncated the proceedings, and the present record prohibits complete review of whether the trial court's concerns justified substitution of counsel. So there's no record of the disqualification and the review of the reasons why these attorneys were disqualified because they withdrew. Yeah, but Rosie said he didn't want to withdraw, and both attorneys filed. So between the 19th and the 31st, both attorneys filed that they wish to continue his representation. So at that point, Frances just said, I don't care, I'm disqualifying you anyway. That's the sum total of the record. Make that make sense. Make that make sense. So blaming them for disqualifying, while simultaneously ignoring the fact that they said that they weren't withdrawing, and then there's no record of what went on because they withdrew, even though they didn't. Therefore, there was no hearing. Make it all make sense. Make it make sense. The present record prohibits complete review of whether the trial court's concerns justified substitution of counsel. That sentence should tell, if there is any justice in the world left at all, that very sentence should have red flag all over it to the good people of the Supreme Court of Indiana. Because the Attorney General of Indiana is admitting right here that he can't tell whether the trial court's concerns were justified because there's no record. Boom. So at that point, everything else he's going to say now is moot. Complete moot. A big fat moot. So you can read that all yourself if you want. However, let's listen to what Francis Gull has to say. All right. Here we go. If you thought that was BS, big fat moot sounds rude. Yeah, it does. It does a bit. Okay. Now remember, right, got to give her a little break here. She's been very unwell. She's got off a sick bed to write this. Okay. So once again, I'm not going to read it word for word because I can smell the BS. As soon as I open the document, I can smell the BS. All right. All right. This court has never issued a writ to reinstate a criminal defendant's counsel, whom the trial court removed for engaging in multiple acts of gross negligence. Bear in mind that what the Attorney General just said is that there's no record to confirm whether or not her justification for removing the counsel is even a thing. Even a thing. Okay. So multiple acts of gross negligence. Okay. Because she had a finding. Remember? She had a finding. She had a finding, even though there'd been no hearing. Oh, dear God. Okay. In disqualifying relator, so relator's Alan, respondent, Gull, did not violate an absolute duty. Moreover, Alan's remedies on appeal are wholly adequate. Well, how do you know? Who would he appeal to? Again, who would he appeal to? You, who disqualified his attorneys. And the Attorney General thinks it's acceptable for his new attorneys to assist him in appealing a decision to appoint them because he wants his previous counsel back. That's an impossible situation to be in. Appellate courts in Indiana across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right. So just because they didn't appeal to her, she's got a problem with it. Relator's petition further fails on the merits. Relator's Sixth Amendment right to effective assistance of counsel outweighs. Okay. So his Sixth Amendment right to the effective assistance of counsel outweighs his limited right to select his counsel. But Richard Allen wants that counsel because he believes they're effective. So let him go to trial with that counsel. No, can't do that, can they? Respondent has discretion to remove counsel where, as here, the record supports that Attorney Baldwin and Rosie were provided in effective assistance of counsel. Wait, hold on. So she's saying there's a record, but the Attorney General said there wasn't an adequate record to be able to find out whether her actions in substituting his counsel for others was justified. So I think these two need to like confer, like get their story straight here. If they want to be on the same side, they need to get the story straight. So, okay, so this is what Rosie and Baldwin failed to do. Failed on multiple occasions to take reasonable steps to safeguard confidential case materials. So, I'm not even gonna go on about Barbara MacDonald and the Purdue report. I'm not gonna go on about all the leaks that have gone on in this case that law enforcement themselves are admitting to. Made extrajudicial statements that had a material likelihood of prejudicing the case. That has never happened. That has never happened. Provided false information to the court. Okay. And, okay. Before removing counsel, respondent afforded relator with what? So she afforded Richard Allen the opportunity to be heard through written submissions as well as argument in chambers and on record in open court. That is a flat out lie. That is a flat out blatant lie. She said she did not want Richard Allen in her chambers. She said it. She said it. It's in the transcript. In her own words, she did not want Richard Allen in her chambers. He was prepared to go to chambers and put the argument, but she didn't want him in her chambers. And he didn't get the opportunity to go on record in open court because she sent him back to prison. She sent him back to prison. That is a blatant lie. Blatant lie. Relator's request for this court to disqualify respondent fails because respondent alleges no bias. I mean, you might allege it. You can allege it till you're blue in the face. Get this. Oh, get this. All right. Right, get this. Okay. So, I don't even know whether she's obviously delirious, you know, she's ill, maybe she's got a fever, but this just tells you everything you need to know. Okay. So, Richard Allen's request for this court to disqualify Judge Gull fails because Judge Gull alleges no bias or prejudice against Allen or his current counsel. What about his previous counsel that you disqualified? You've definitely got a bias against them, haven't you? No, you don't have bias against Scremin and Libretto because you know that they're your little fanboys. They're your friends. So no, she can honestly say that she's not got a bias against them because, oh, you know, they'll do the right thing. They'll put up a really weak defense and then he'll get convicted. Or they'll strong arm him to plead guilty because that's what Libretto likes to do, according to some of his reviews on Google. So, yeah, that's true. She has no bias towards Libretto or Scremin. What about Rosie or Baldwin, though? Who is the relator? That's Richard Allen. It's out of focus. It's not. You need to, if it's out of focus, okay, go to the little wheel that says settings, hover over the wheel, and then change your quality. So it's on your screen, not on mine. So change the quality to 720. Because StreamYard only streams in 720 anyway. So change it to 720. Yeah, that's right. The Attorney General didn't want to act as her attorney, but sticks his nose in anyway. Yeah. Sticks his nose in the shit and makes it worse. All right. Okay. So Richard Allen's lone assertion for the judge's removal is the trial court's ruling to disqualify his prior counsel, which she has not. She's not said she's not biased against them. She's only said she's not biased against his current counsel. But a trial judge's adverse rulings are not insufficient to demonstrate a judge has personal bias or prejudice. Okay. All right. So here we get the legal bit. Okay. All right. So never issued a writ. So it's basically just saying what that introduction said, but with the legal argument alongside it. So again, you can look all this up if you want, but okay. So Richard Allen relies on most part on cases from outside Indiana. So what? There ain't that many of these cases around. Indiana has never seen anything so messed up as this. So, you know, she's messed up the entire case and then comes along and says, oh, well, they're using legal argument from outside of Indiana. The reason why they've got to use argument from outside of Indiana, because no one's ever messed up an Indiana case so badly as her. Okay. When interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. What about the Constitution? Okay. Relator identifies no case from this court or the United States Supreme Court that affords him a clear right to an extraordinary writ for his relief he seeks. Well, that's up to the Supreme Court to decide, not you. So if we're still talking about settings, this is streaming in 720p. So you should be able to get 720p. All right, so all petitions shall state blah, 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 blah. What's this to? Relators' remedies by appeal are wholly adequate. All right, so again, I'm going to appeal to her. She's going to deny it, and it's going to go to the Supreme Court anyway. And she's already got a bias, and she's admitted it. She's admitted it by saying she's got no bias to his current counsel. She's admitted it by omission. Because what she actually should have said, because the argument is with the prior counsel. So what she should have said was, I have no bias or prejudice towards relator or his prior counsel. But she didn't say that. Okay. Trial court did not violate Sixth Amendment right. Okay. So we know the argument there. Respondent properly exercised her discretion to protect relator's Sixth Amendment right to effective assistance of counsel by removing Baldwin and Rosie. All right. But she did not afford them the same right that she afforded Slick Nick, because he was able to bring his witnesses because he'd been given prior notice. The trial court is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused's Sixth Amendment rights, competent and effective assistance of counsel. This court has explained that the trial court must be given latitude in its efforts to navigate the Scylla and what? Okay. We conclude that trial court discretion is necessary because the tension between these two important rights must be resolved by the trial court. Gross incompetence, okay, that cannot be cured by a citation for contempt may justify the court's removal of an attorney, even over the defendant's objection. So did she find contempt? Did she find them in contempt of court? She didn't, did she? She didn't find contempt of court. She said she had a finding, but that wasn't explained, was it? So what was the contempt? What was the contempt of court? So why even put that citation in when in this case there's no contempt? The trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. The only person who's constitutionally defective is you. The only person who's made this case unconstitutional is you, Francis. They've done nothing that would constitute gross negligence, gross incompetence, contempt of court. If they have, then prove it. If you were able to prove it, then and the due process was followed, then I wouldn't have a problem with it. I wouldn't have a problem with it. The problem I've got is this is an absolute farce. Absolute farce. And honestly, I think the Supreme Court will buy all this bullshit. I really do. I think they'll rule in her favor. No, Mother McReady, no. She had until the 16th to do that. That was from the first writ. So no, she'd not done all of that. She'd not done it. I can prove it. Okay. I'm going to have to put my VPN on. If you disappear... Okay, am I back? Yeah. By the looks of things, I'm back. All right, I'm now streaming from New York City. All right, so we've got state of Indiana. So that's the case that we're currently talking about. 311. That's the other writ, 302. This is the murder case. All right. All right. So all of these things that she's supposedly put in the CCS, they're not there. The words are there, but there is no actual links to any documents. None. None. She's not put any documents on the CCS. Not one. So all the words are there, but compare that to this case that we're talking about right now, the Supreme Court. When you see a link that you can hover over, it means that that document's available. Document available, document available, document available, document available, document available. And then today's documents are down here. This is this document that we're talking about here, document available. That's the document we've just looked at. So again, look at the murder case. No live links, not one. Not one. Don't know what to tell you. She's a liar. She's an absolute liar. So, Baldwin and Rosie failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. Rosie had nothing to do with that. Rosie had nothing to do with it. So she goes on about Mitch Westerman. Yeah, we know all about that, yeah. Why did he do that in the first place, and why did he wait for 2 months with those in his possession to reveal them? Okay. Baldwin emailed confidential work product to an unauthorized person. Okay, all right. That was a mistake. I'll admit that one. Baldwin and Rosie made extrajudicial statements that had a substantial likelihood for materially prejudicing the case. So that was press release on November 29th. So before the gag order. And although some people might not have liked it, there was nothing in there that wasn't true, and there was nothing in there that was prejudicial. Got the press release, talked about the press release. I've played the interview that Baldwin did. Okay. Baldwin and Rosie provided false information to the trial court. All right. Okay, because the warden of Westville and Slick Nick thought that Westville was great, like you know, as good as a holiday camp. All right. Okay. So the evidence presented demonstrated that the defendant is treated more favourably than other inmates housed at Westville. So if he's treated more favourably than the other inmates, well, I feel so sorry for all the other inmates then. What is the standard of care towards these human beings? Yeah, they might be dreadful humans, but what is their standard? What standard are they working from? As a result of these events, the trial court became gravely concerned. What about, hold on a minute. So we've only got 4 points here. What about the conflict of interest from Rosie? The Attorney General said that there was a conflict of interest that Rosie had because he'd filed a tort claim. That's not even mentioned here. So that's not part of her argumentation, apparently. So the conflict of interest that the Attorney General slipped in there, she doesn't seem to have a problem with. Or maybe, you know, while mopping her fever brow, she just forgot to mention that. Maybe she just forgot. So for those reasons, that's why they needed to be disqualified. Okay. So adequate notice. All right. So she told him that there was going to be a hearing, although there was no motion, no notice of that hearing through a motion. So we've got all these letters and blah, 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 correspondence. But Rosie asked what the purpose of the October 19th meeting was about. And she absolutely did not, absolutely 100% did not allow Richard Allen a right to make his argument either in her chambers. She point blank refused to have him in there, even though he wanted to be there, or in open court because she sent him back to Westville. I mean, do we really need to go on? It's just absolute bullshit. It's respectfully request that this court deny Relator's verified petition for writs of mandamus and prohibition. So honestly, I think that the Supreme Court, I have a funny feeling that they're going to buy this crap. I hope not. I sincerely hope not. I sincerely hope that there is genuinely objective people who work at the Supreme Court and are able to see through this BS. Otherwise, what hope does anybody have? Certainly, you've got no hope in Indiana. Yeah, they streamed the or at least some of the protest. I put the link in my community this afternoon. Well, it was their morning. There was a lot of kind of downtime in it. Yeah, it is. Guilty till proven innocent. I mean, listen, none of this for me is about Richard Allen, really. None of this. It's about fairness, justice, true justice. And combined, just some of the words that the Attorney General has said and then some of the words that she said are just very, very telling. That it's a stitch up. It really is. And I really hope that there's an objective person in the Supreme Court who's prepared to go through all of it and understand the issues and not just take her word for it. The Attorney General was reprimanded on November the 3rd for misconduct. Why? What did he do? What did he do? Well, maybe he's had things on his mind then. And that's why some of his words are a bit contrary to how they should read. That's true. Exactly. I mean, would this be happening to somebody like, let's say, Alec Murdoch, for example? You know, who's got the money to pay for the attorneys of his choice and for them to just keep filing, you know, motions and appeals, and, you know, money isn't an object. If that's the case, then yeah, you can go the long way around. You can be afforded truly the counsel of your choice. But when you're relying on a system that's weighted against you, and it shouldn't be. The scales of justice should be even. Doesn't matter if you're guilty or it doesn't matter. Doesn't matter if you did it. The scales of justice should be even. You should have the right to a fair trial, and be tried by a jury of your peers. That's the law. It's a law in Indiana, just like it's a law here in my country. Judge Gull's Google reviews are brutal. Looks like she's been at it a while. Yeah, and she's been at it and she's got away with it. So what can you say? How far up does it go? Well, they're all friends. It's a good old boys network. The good old boys of Delphi. Go and watch my live stream called The Good Old Boys of Delphi. I'll show it you. It's from... Is it on this channel or is it on the other channel? Might be on the other channel. Oh, there it is. There, go and watch that. She's got a couple of hours to spare. The Good Old Boys of Delphi. Go and watch that. Yeah, exactly. Fair trial seems to have a varied interpretation. Yes, absolutely. So is Judge Gull still in the case? Yeah, Judge Gull has responded. She had until close of business today to respond, and she responded about 4 p.m. Indiana time, Eastern time. So yeah, she's still in the case. She's not recused herself. She seems to be in it for the long haul. And I think that she's gonna stick it out. I think she's gonna stick it out. Oh, I'll have a look at my poll. What did my poll say? I did a poll earlier on. Okay. So, do you think that Judge Frances C. Gull will recuse herself from the Delphi case? So, a third said yep, and 2/3 said nah, she'll battle on. End of last week, I thought, you know, her office have put out that statement that she's been unwell, and the fact that she kept that hidden for 19, 20 days, there was no reason for her to say that she was unwell, that she'd been in hospital. So it was like leading up to something, leading up to her recusing herself on medical grounds. But seems not to have happened. Seems not to be the way she's gonna go. She's gonna fight this. And I think, honestly, I think she'll have enough friends that she'll win. She's greased enough palms for her to skate through. I mean, why she wants to carry on with this case, I've no idea. Looking for sympathy, you might be right, Mike. When does the march start? It already happened. 9 a.m. Eastern. Already happened. There was a live stream by The Unravelling there. So they streamed for about half an hour, but there was a lot of muting and stuff. So there wasn't a great deal to see apart from some people marching, and yeah, it happened. Joanne, I've just said it happened. So it was only quite a small turnout, but they marched. They did what they said they were going to do. It would have been nice if there'd been more people turn up. But I guess 9 o'clock Monday morning, you know, people have got work. They'd have to take maybe a holiday day to get time off work. Kids, school run Monday morning, that kind of thing. So I kind of understand why it's not a great time. I think they'd have got like way more if they'd have done it at weekend. But then again, the Supreme Court doesn't work weekends. So what can they do? They had to do it today because it was the day, her deadline for this writ. It was symbolic. The day, choosing that day was symbolic of it's her deadline day. It's, you know, what's it to be, Fran? You know, put up or shut up kind of thing. So it had to be that day, but the time was 9 o'clock Monday morning. I mean, in the in cold weather, people have got other places to be. Do we know what the families think about what's going on? No, the families are gagged. So they can't come out and make statements. I mean, obviously, if people know the families, they might have expressed an opinion, but they can't make their opinions public. So we don't know what the families make of it all. They could have taken President's Day. Yeah, but the court wouldn't have been there because they have their Lincoln Day on Friday, last Friday. This old nurse, you've missed pretty much the whole live stream. There was court filings from Judge Gull and from the Attorney General. So I haven't read them word for word. They were like 20 pages each. And it's just more BS. Circular arguments, more of the same. It's like Groundhog Day. Baldwin tells the wives it ain't over. Tells me she's supporting him. Kathy Allen. Yeah, Kathy Allen was crying on October 19th. She was like in floods of tears. So yeah, she is supporting Baldwin. I mean, look at the state that Kathy Allen must be in. I mean, you know, it was due to go to trial. They had a really good defense. They had a team that was really working above and beyond, way above and beyond that, you know, the average public defender would do. They were his very best chance of getting off or something. And it's all been, the rug's just been pulled away from her. What's the process now? Waiting for the Supreme Court to make a ruling on both writs. So the deadline for responses to the first writ was the 16th. So that'll come first. And then the deadline for this writ was today. So that's only just gone. So it's going to be a while before. I mean, I've no idea. I don't know how long these things take. I don't know if there's a specific time frame that they've got to respond by. I've no idea. I don't know how it works. I do, Jill. Real sinking feeling. So do I. I was actually feeling quite positive last week. I was thinking, yeah, she'll recuse herself. All will be good. They'll get a new judge who is actually fair. And at the very least, Baldwin and Rosie should get a fair disqualification hearing. If that judge, the new judge, looks at the totality of the evidence and says, look, fellas, I really do think you've been negligent here. However, let's do this properly. Let's call a hearing. You fellas bring your evidence and your witnesses, and let Nick bring his, and I'll make a fair ruling. I'd be happy with that. I really would be happy with that if it was a judge who was truly fair. But there's nothing fair about this. This is an absolute stitch-up. Exactly. If he has been set up, he's a victim as well as the girls. He is. As is his family. Yeah, if he's innocent and he's been stitched up, this is absolutely appalling. I don't have the words. But if he's guilty, and I genuinely don't know, if he is guilty, if he's the guy, then he should have the right to a fair trial and be found guilty by a jury of his peers. As simple as that. Simple as that. See ya, bug glove. Gotta pop out. He's innocent till proven guilty in a court of law. So legally, he's an innocent man. Factually, he either did it or he didn't. And if he did, again, he has a right to a fair trial, to be tried and convicted by a jury of his peers. And if he's found not guilty, if the prosecution did not meet the burden of proof, then the jury finds him not guilty, even though he did it. But that's justice. I'm sorry, that is justice. If the prosecution don't meet their burden, the jury has to find the defendant not guilty. Think Casey Anthony. Think Casey Anthony. The prosecution didn't meet their burden. They over-egged the pudding. If they're given the jury the option of second-degree murder, she'd probably be in prison by now. Still be in prison. They didn't. They went first degree. Oh, I know, Janet. We've had this conversation lots. I know Lincoln's birthday is in February, but some counties in Indiana celebrate Lincoln's birthday on the Friday after Thanksgiving for some strange reason, unbeknown to nobody but those people who've decided that. Yeah, it's frustrating when you have somebody who you who you know, who you just know in your soul did it. And the prosecution did not meet the burden, and the jury could not find her guilty of first-degree murder. And if they genuinely could not, beyond a reasonable doubt, say that she was guilty of first-degree murder, they did the right thing in finding her not guilty. But that's justice. That's the process. That's how it works. That's a fair trial. It's a fair trial. And Richard Allen should be afforded that. And this is anything but that. All right, guys, I'm going to go. I've talked far too much over the last few days, reading hour after hour of the College of Policing report on Nicola Bulley. So if anybody followed the Nicola Bulley case and want to know the findings of the independent review, then there's 6 live streams over on Michelle Walks. Each of them's like 2 hours long. Today's was shorter because the chapter was shorter. But yeah, if you want the facts on the case and not the nonsense on the case. All right. Thanks for joining me once again. Don't think I had any donations. If I did and I've missed it, I'm really sorry. I don't think I did. I think I'm good. Oh, final thing before I go. For those of you who were members, I did mention this in one of my Nicola Bulley lives the other day, but I'm going to do a members live on JFK. So I asked people. So it was a bit weird because that was on Michelle Walks and I don't have memberships over there. So I'll ask again here because there's more people in and some of you are members. But I asked people the other day whether they'd like a members live on JFK, and people said yeah. So I am going to do it. I don't think it's going to be tomorrow. I don't think it's going to be Wednesday. Probably looking at Thursday or Friday, depending on what on earth goes on in this case. But the way that I liked members' lives to work is that everybody across, you don't even have to be a subscriber, let alone a member, to view it when it's live. But only members can chat. And then once the live stream ends, then the replay is only available to members. So if you're not a member and you want to watch it, you will have to catch it live, or else you won't be able to watch it. I think that's fair. It's like a fair way to give members something extra, that members get the opportunity to watch it on the replay if they couldn't catch the live, or watch it twice or whatever. But I don't like putting too much content behind a paywall. I feel a bit icky about that. So, but members have to have something, because you guys support me month on month on month. I've got some members now who've been a member for more than 2 years, So you deserve some extra content. So that's kind of the way that I'm kind of doing it as fairly as I can for everybody. All right, so it'll be JFK assassination because it's 60 years, isn't it? It was 60 years just a few days ago. And yeah, I've been wanting to talk about JFK for ages. Ages. The grassy knoll. Oh, yeah. All right. It's going to be a bit graphic, though. I will put a big warning on the screen. It's going to be graphic. But, yeah. All right, guys. I actually let Kyle, my son, look at the autopsy photo of his head and the actual shooting, and he didn't find it gruesome. He went, "It's mad that." It's mad that. All right, I'm going. Thanks as always to the mods, and thanks for being here, keeping me company. I'll see you tomorrow. Bye, guys.